Hello, everyone, and welcome to Uncivil Law. For today's decision, we're looking at a judge in Oregon who says that private property rights are passe. We don't need any of those private property rights because society and life changes, and that itself is enough reason. We don't need any reason or thought beyond that. Just merely society changes, and that change is good, and that's all we need. Okay, so we're in Oregon in Clackamas County in the case of Mark Kramer and Todd Prager versus the city of Lake Oswego and the Los Oswego Corporation. Okay, and we're going to read this decision and analyze it. Okay, so let's start. Women didn't used to be attorneys or judges, yet here we are. Life changes. All right away, we're off to a really bad start. We're off to a very bad start. This is basically a fallacy. This is an appeal to modernity. This is an appeal to novelty. Because it is new, because it is modern, because it is progress, it is inherently good. Which, of course, is not true. And also, so first of all, it's just not true because there's a lot of things that have been progress that aren't necessarily good. Just because it's new and progress doesn't necessarily mean it's good. Second of all, it's also bad because it doesn't even seem to contemplate why that difference exists or why that difference is good. It's just basically once women were not lawyers and judges, and now they are. Life changes. But it's really, really sloppy. And it's really just banal because there's no thought or reason into, hey, why did that change? What was the rationale for that change? Now, I mean, it's equal protection is the answer. But when you write, women didn't used to be attorneys or judges, yet here we are, life changes. There doesn't even seem to be a thought in the back of this judge's head that change had a reason or a rationale, incidentally, which might not necessarily apply to another context. There might be another context in which that rationale would not make sense. And it doesn't even seem to acknowledge that there is a rationale at all. It's just this used to be true, and now this is true. Life changes and suck it up. It's like, well, why should we accept it? Why should we accept this change? Again, the answer is equal protection, but it's just, and also like people had to fight for that change. And also the change itself is relatively modern because that's a relatively modern conceit. But it's lazy in so many ways. It doesn't seem to even contemplate there was a reason for it. It doesn't seem to contemplate anything. It's just like, well, life changes and suck it up. It's like, but no, you can't do that. It's like, no, it makes sense or not on its own merits, its own rationale. It's like, you can't. And okay. Sentence number 2. Old deeds to property on the lake used to prohibit the sale or ownership by minorities. Life changes. Yeah, the U.S. Supreme Court had a case on that. You can't just... She doesn't even cite the U.S. Supreme Court case, incidentally. Or, acknowledge that there was a case. It's like, yes, deeds used to say that you can't sell to black people, for example. That used to be in deeds. And the U.S. Supreme Court was asked once, hey, can you do that? And the Supreme Court's like, no, you can't. And the argument why you could was, well, it's just private action, right? A deed is private action. It's a person did it and another person bought the property and they bought it with that condition. And so that's just a condition. And so it's private action. And the U.S. Supreme Court said, well, that might be true as far as it goes. But the problem is once you get the courts involved, now it's no longer strictly private action. Right? Once you want to try to get that deed enforced, once you want to go to court to enforce that agreement, now you're invoking the power of the government. So the deed itself, maybe that's private action, but once you go to the court, now you're invoking the government, and the courts are the government. So the reason that these covenants are not lawful is because the government can't discriminate on the basis of race, because racism is bad, because 13th and 14th and 15th Amendments, because slavery, because of oppression and the history there too. But she doesn't even cite the US Supreme Court. She doesn't even cite the case. She just says, well, old deeds used to prohibit the sale of minorities and life changes. Life didn't just change out of the ether. It didn't just happen. There was a whole court case over it. The US Supreme Court had a whole rationale for it. They said that the enforcement of the deed was state action. And that was the problem. It's just, okay. In 1972, the United States Congress passed Title IX, prohibiting gender discrimination from public schools, requiring public funding. Life changes. I don't even know like how it's possible for you to cite the thing and also not acknowledge the thing at the same time. That's truly amazing. How do you cite the thing and not acknowledge the thing at the same time? She's like, well, in 1972, Congress passed Title IX. Life changes. Well, no, life doesn't change. Congress passed a law. They passed it. You just said it just now. It's not like it just popped out of the ether. It's not like it was just handed from on high. It's not like it just, magically we woke up one day and there's this thing called the Civil Rights Act. Congress passed a law. They debated it. And they had a discussion over it. And you know what Congress said? What if we didn't have gender discrimination at schools? That might be good. And they passed Title IX. But it's just life changes. No, it's not just. Okay. It just happens. It just happens from the ether. Okay. All right. Now. In 1974, women in Oregon couldn't open a bank account without either their parents or their husbands. Life changes. I mean, again, the Civil Rights Act, which we're not even going to acknowledge at this point. Equal protection of the law. Maybe we should treat men and women the same. Maybe that would be good. Maybe men and women should be the same. That seems like an interesting idea. What if we did that? Hey, bank, which you are pretty much interstate commerce. So like, hey, bank, since you are, pretty much interstate commerce, we really think men and women should be treated the same. Here's a law to make you do it. But life just changes magically. For some reason in 1974, things just changed magically. What is this thinking? What is this thinking? It's lazy. It's stupid. It's stupid thinking. Until 2014, Oregon's same-sex gender couples could not legally marry another person of the same gender. Life changes. Anyone want to cite anything at this point? Anyone want to? That decision had a rationale to it. Incidentally, I didn't think it was the best way to write the decision. Although I agreed with the decision, I didn't really like the way Justice Kennedy wrote Obergefell. I didn't think it was well written. It was too floaty. At least, although it was more solidified than whatever this is. But there was a rationale to it. And a whole court case over it and everything. It's like, okay. Thank you, Ellen, for the gift memberships. We do appreciate them as always. Oh, Lord. All right. So life just changes. Life finds a way, I guess. The issue before the court here is under the laws and regulations and rules, life has changed enough to how we treat and protect the public interest in the lake. Does anyone else think that's a non sequitur other than me? Because I kind of think it's a non sequitur. Hey, once women couldn't be judges, now they can. Hey, once women couldn't open bank accounts, now they can. Now I'm going to decide the public interest in a lake. Unless the lake includes the lady of the lake who's giving out swords. I'm not sure how it follows. I'm not sure how that follows. It doesn't really seem to flow. Okay. In 1972, in the Dark Ages, I guess, the defendant city passed a resolution and related park rules which barred public access to the waters of the lake from certain of the city waterfront parks in downtown Lake Oswego. Okay, so public, you can't get to the lake by these means. You can probably think of any number of rational basis reasons for that. Why might the public not be allowed to access the lake from those places? You can think of reasons. Traffic management being like perhaps the most obvious. Damage to the environment because people accessing it more places could be more problematic. You want to slow the flow of the amount of people that access the lake, so you slow the amount of ports that they're able to enter the lake. So you're reducing traffic on the lake itself. Environmental management of the lake. Too many boats. I mean, there's any number of reasons that you might want to do this. But we're not going to contemplate any of those reasons in any way. It's just the city said you can't access the lake from this place. But they just said it because they're a mean, mean city. I'm sure there weren't any reasons behind it. Help me. In an earlier appeal of this case, the Oregon Supreme Court held that public interest in the navigatable waterways that are held in trust by the state includes a right of access to publicly owned water from abutting public land, and state interference with public exercise of that right must be objectively reasonable in light of the purpose of the trust and circumstances of each case. Which, okay. It sounds kind of like a rational basis review to me. But yeah, you can access the lake, but they might be able to restrict where exactly you access the lake because there might be reasons. What are those reasons? And then we can analyze it, I guess, and we can decide on that, I guess. Okay. In the case, the court found that the government actions may not substantially impair the public's right to use the waterway without adequate justification. Okay. In other words, the city may not substantially impair the public rights to use the lake for public trust purposes without adequate justification. Okay. The Supreme Court remanded to this court on two remaining questions. The preliminary question of whether the lake is subject to the public trust doctrine, and if the lake is subject to that doctrine, the resolution of the factual dispute regarding whether the city's restriction on entering the lake from the waterfront parks unreasonably interferes with the lake from the abutting waterfront parks. Well, that's not quite right, but okay. After the Phase 1 trial, this court concluded that the lake is subject to public trust doctrine, and there is a public right of access to the waters of the lake from the city's waterfront parks under the public trust doctrine. Okay. So the lake belongs to the public. It's a public lake, and so the public has the right to use the lake, generally speaking. All right, that kind of makes sense, I guess. The court rejected the defendant's corporation argument The portion of the lake known as Lakewood Bay is a separate body of water from the rest of the lake. Okay. I suppose that would be a technical question, which I'm not sure how that would get analyzed under relevant law, but they think it's not a separate body of water. Okay. That resolved the first question. On the second question, as explained in their complaint, plaintiffs seek 3 declaratory judgments. They also sought injunctive relief, enjoining the city from enforcing its exclusionary lake use policies, enjoining the lake from erecting or maintaining fences, boulders, metal reeds, no trespassing signs, and private lake signs on publicly owned abutting lake, enjoining the lake from erecting or maintaining other obstacles designed to or prevent or discourage the exercise by the public to reasonable access, and enjoining public access in the design and development of future lakefront facilities. The issue to be resolved in the phase 2 of the trial was whether the resolution and related policies prohibiting public access from public parks unreasonably interfere with the people's right of access. The burden is on the lake to show that the restriction is objectively reasonable in light of the purpose of the trust. Which is interesting, incidentally, because under standard, and this apparently comes from, where's this coming from, this standard? It at 14. Is this coming from the second amended complaint? That's a sloppy cite. That doesn't make sense. So they say, okay, the plaintiff site seeks this relief. Okay. And then they start citing from the amended complaint, right? Plaintiffs seek 3 declaratory judgments as set out in the amended complaint. So the thing we're citing is the amended complaint. Okay. And then they start citing paragraphs of the amended complaint. Okay. And then they say, there's no citation to this at all. There's no citation for this proposition. The burden is on defendant city of Lake to show that its restriction is objectively reasonable in light of the purposes and trust and circumstances of the case. There's no citation. Where's that coming from? Where's that coming from? If it were rational basis, it would be the other way around. Typically, rational basis, the burden is on the private party, not the government. And it kind of sounds like a rational basis review, which would mean it would be on the party to show it's not rational. But they say the burden is on the government, but there's no citation. It's just coming from somewhere. It's just coming from somewhere. The Oregon Supreme Court decision? Maybe it's the Oregon Supreme Court decision. I have no idea. There's no citation. I hate it. The defendant state of Oregon's position is that it did nothing that substantially impaired the recognized public use. That's true. The state has taken no action to restrict public access. Therefore, it's dismissed with prejudice. Okay. The right to access to water bodies subject to the public trust is not absolute. The assessment here of the reasonableness for the city resolution is a matter of law. This court must employ a balancing test that weighs the who dismissed with prejudice? In what form did they dismiss with prejudice? Who is it? The defendant state of Oregon's position is that it did nothing to substantially impair the recognized public use. That's true. The state has taken no action to restrict. Therefore, it is dismissed with prejudice. Oh, you're speaking about yourself. It is dismissed. What is dismissed, though? Do you mean the state of Oregon is dismissed as a party? Do you mean that the cause of action is dismissed? Because if the cause of action is dismissed, why are we still talking? This is some fucked up shit. What is it? It is dismissed with prejudice. What is it? The right of access to water bodies subject to public trust is not absolute, but we're still talking. So presumably it's not the cause of action because we're still talking. The assessment here of the reasonableness of the city's resolution is a matter of state law. Okay. The court must employ a balancing test that weighs the magnitude of the restriction against the government's interest. The greater the restriction, the more compelling the government interest needs to be. Okay. Restrictions and closures adopted by the State Land Board and Department of State Land are tailored to meet specific concern, are limited in geographic scopes, and place minimal burdens on the time, place, and manner. The rules reflect the state's obligation under the public trust to prevent a substantial impairment of public use, right of water bodies subject to the public trust doctrine. Restrictions on access should be limited in area, time, duration, and scope as necessity. So now it sounds like we're doing intermediate scrutiny, in which the burden would be on the government. When we start talking about a time, place, manner restriction, although normally we talk about that in a First Amendment context, but now we're talking about boats and lakes. But it sounds like we're doing an intermediate scrutiny analysis of some kind. This decision confuses me. The right of public access to water bodies is subject to public trust is not absolute. Well, you told me that. However, the cities may not take actions to substantially impair the public right. However, it must be objectively reasonable in light of the purpose. You told me that already too. The objective restriction is one that does not substantially impair the public right without adequate justification. Okay, clearly this is where a balancing test comes in. The balance is the magnitude of the impairment against the asserted interest. I mean, you already told me that too. Are you going to tell me anything new? Here, the city of the lake resolution restricting all public access to the lake substantially impairs the public right of the access. Well, I mean, that would have to be true. I mean, by necessity, right? The restrictions must be based on determination action is necessary to protect human life, health, or safety. Really? That's all it can be based on? That seems odd. It can't be based on protecting marine life or protecting overcrowding, protecting traffic, protecting noise, protecting pollution. The only thing it can be based on is human life, health, or safety? That seems like odd, if true. An advisory jury was chosen to determine the factual findings in this case. The advisory jury's findings are not binding, although findings can be helpful in determining facts specifically. The court can accept or ignore the jury. Then why do we have one? Why do we have a jury? Why do we have advisory juries? The court makes conclusions of law on whether the resolution is objectively reasonable as a question of law. Well, you also make conclusions of fact, I guess, too, because the jury is optional. In this case, the jury found unequivocally, which, doesn't matter, but we're going to tell you what they found anyway. The property boundaries of the city and lake park properties provide a reasonable basis for restricting physical access at Sunder Life Plaza and Heldy Walk only. The restrictions on the city's property interests provide a reasonable basis for restricting physical access to the bay at Sunderleaf Plaza and Headley Waterway. Okay. Interesting, I guess. The design and construction of the parks provide a reasonable basis for restricting physical access at those places only. Potential legal liability risks to the city do not provide a reasonable basis for restricting physical access at those places only. The safety of lake users provides a reasonable basis for restricting physical access by the public from Sunderleaf only. The expenditure of city resources by the city does not provide a reasonable basis for restricting physical access to Lakewood Bay. The water quality at Lakewood Bay does not provide a reasonable basis for restricting physical access. Wait a second. Now you've confused me again. You've confused me again. What do you mean the water quality does not provide a reasonable basis? What do you mean? Because you said up here on lines 12 and 13, The restrictions must be based on a determination. The actions are necessary to protect human life, health, or safety. But then, on line 8 and line 10 and line 12, you're talking about the expenditure of city resources, water quality, and invasive species, none of which is human related. Right? I mean, I would think that these might be a reasonable basis, like the expenditure of city resources, the water quality, or risk of invasive species might to me seem like a reasonable basis, but you told me restrictions must be based on determination the action is necessary to protect human life, health, or safety. If that's true, then why are you talking to me about city resources, water quality, and invasive species? How does that make sense? Are they relevant or are they irrelevant? I'm confused. I don't understand. Invasive species only get there via boats? It doesn't matter. The health of the lake? It doesn't matter. That's my point. It doesn't matter. The health of the lake is irrelevant. Invasive species is irrelevant because they said on page 4, line 12, the restrictions must be based on a determination the action is necessary to protect human life, health, or safety. Invasive species is none of those things. The health of the lake is none of those things. Therefore, they're irrelevant. Why are we talking about them? Right? I mean, I'm reading this correctly, right? The restrictions must be based on a determination the action is necessary to protect human life, health, or safety. Why are we talking about water quality? Why are we talking about invasive species? It doesn't matter. It's irrelevant. You told me it was irrelevant. I'm so confused. The lake is filled by water from one river isn't a permanent lake. Well, whether it's permanent lake or not is not the issue that I'm trying to figure out right now. But okay. Yeah, it doesn't make sense. It doesn't make sense. I mean, I would agree with you personally that invasive species and water qualities could be reasonable considerations. I mean, I think those seem like reasonable considerations to me, but they told me they weren't reasonable considerations. So if they're, then why are we talking about them? Like, the court can only speculate that a few inches between the water of the bay and the fence line provide a potential legal liability to the city. Of course, the defendant assured the city there was no litigation over the 1-inch difference between the water line and the fence line, and risk of liability is limited by the city's immunity from liability. Well, that would definitely limit the risk of liability quite a lot. The risk of liability is limited by immunity. I'm not sure limited is strictly speaking the right word there. I wouldn't necessarily say limited. I'd say eliminated would be closer. The court can also only speculate the dearth of evidence concerning ownership and lease agreement regarding Heldley Park provided a potential liability to the city. It's too bad, as this would seem to be a perfect place for boats to launch without much cost. but it can't because there's an immunity. That doesn't follow. If there's immunity from liability, you can't then turn around and say, well, here's the reason that there's liability. Do you know how immunity works? There's immunity. Also, the court speculates as to here's why there's liability. I'm not sure the court understands how words work. Okay, that leaves Millennium Park. The jury found no reasonable restriction to entering the lake from Millennium Park, and so no potential legal liability risk to the city. But I thought there was immunity. I'm confused. The jury found no reasonable restriction to entering the lake, and so no potential legal liability. But there's immunity. You said so in line 23. You said there's immunity. So what are you doing analyzing facts now? If there's immunity, all facts are irrelevant because there's immunity. All facts are irrelevant because there's immunity. Do you understand how immunity works? Okay. The risk of invasive species, water quality, which for some reason we're talking about, despite the fact that we're not allowed to use those reasons, but for some reason we're going to talk about them anyway. The risk of invasive species, water quality, and safety of lake users was also not proven. Only two of those things are potentially relevant. Only two out of those three things are potentially relevant. Or even one of those three things is potentially relevant. Maybe there's a limited immunity to some causes of action. Maybe, but then again, that's not what they wrote. So I'm still back to the court doesn't understand how words work. So maybe there's some limited liability, but what they wrote was, and the risk of liability is limited by the city's immunity from liability. So either way, you're having to change what the court wrote. Also, the court wrote that the only considerations that matter are human health and safety, and for some reason we're talking about invasive species and water quality. I don't like the way this decision is written. While the city claimed it was unreasonable to allow entrance to the lake because of the park's design and construction, the design and construction was provided by the city. They cannot cause the unreasonableness and yet use that unreasonableness as a defense. Well, I don't think that's quite true. If you can show they did it like deliberately for the purpose of limiting access, if that was like their motivation or goal, then I think yes. But if they designed it for other reasons, and there would be any number of other reasons to design it that way, it's like, oh, this isn't a really good place to enter the water. Now, if there are no reasonable places to enter the water, then I agree you have a problem because now you've unduly restricted access to the entire thing. And so like, you can't like use this defense universally, but it makes sense to me that you'd say, you know, we didn't really design it for this reason. There were really good reasons for us to design it this way, and be like, oh, okay. Yeah, you can't use this landing point. It wasn't really designed for that. We designed it for this, for that, for these reasons. But you can enter the water here, here, and here. And as long as those are anything approaching reasonable, it sounds okay to me. Yeah, thanks, Mike. I'm working on the logic. It's fine. So I mean, I do appreciate that, you know, you can't really like be like, I broke it, therefore I'm not responsible for it. But that doesn't quite work here, right? You can't quite be like, I burned the thing down. It's the hubris. It's the old classic hubris, you know. Take old classic hubris, you know. Take pity on me. I'm a widower, but I'm accused of killing my wife. Right? It's like that's the definition of hubris, right? Take pity on me. I'm a widower, but I'm on trial for killing my wife. So I do appreciate that you can't like invite your own error, but that doesn't quite work here because there are lots of very legitimate reasons to design the borders of the lake in such a way that might inhibit access. But that wasn't really your goal. It's just an aside for any number of legitimate reasons. But we're going to ignore any potential legitimate reasons, I guess. So the construction of the steps that can be adjusted so they avoid the easement of the railroad can be made ADA compliant pursuant to state regulations, and have access to sloped areas of the left of steps, which can be made safe with vegetation removed for improvement of the area. The vegetation of metal sculpture, okay, could be moved. Why are we calling metal sculptures vegetation? Even in quote marks, why are we calling it vegetation? The vegetation in metal sculpture could be moved from the area in the water to elsewhere on the walkway, for example, making the area safe for entrance of people in their boats. Although you're potentially messing the aesthetic design, right? Maybe there's a reason it's there for the sake of the aesthetic. So like you are potentially messing with the aesthetic, which you don't even like acknowledge. That's my thing. Like, it's not that you've like, and while that, is aesthetically beautiful, it's more important that people have access. There's like no consideration about why the gate is in the middle of the field, right? Why is that gate in the middle of the field? I don't know. Let's just move the gate. It's really annoying. No, you gotta like, why was it put there in the first place? Was it put there for the purpose of trying to deny people access? Was it malicious? Was that the reason it was put there? If it was malicious, then sure, I guess. But what if it's not malicious? Well, maybe it's just more important. So maybe it's more important than the aesthetic, and it'll be okay. But like, there's no consideration of it at all. There's no consideration of why things were the way they are. It's just like, we can do this and it will fix this problem. Yeah, maybe you can do this and it'll fix this problem. But what else are you creating along the way? There's no consideration of it at all. It's sloppy. It's sloppy. Reasonable use restrictions could have been determined and advertised by the city, such as permits, fees, cleaning of boats, number of times, enforcement by the police. This would not be too expensive, according to the jury. Furthermore, reasonable use restrictions can be limited in area, duration, and scope as necessary to address the needs of the restrictions. And the magnitude of the above restrictions is minimal when compared with the public use of the water bodies. Well, at least then they're trying to balance it out, even if it is a bit conclusory. But at least they're like acknowledging there's another thing. Managing the risk is reasonable. Banning the public outright is unreasonable. Well, I appreciate that. I appreciate that banning the public outright might be unreasonable. But like, I'm not sure you're thinking this all the way through. The case said that one can invalidate legislation, as it did 5 times listed at the beginning of this opinion, if the legislation is unreasonable. Well, that much is true. Although, what do you mean by unreasonable exactly? But if you mean arbitrary and capricious, then that's always true, right? That's just the other side of rational basis. If you don't have rational basis, it's arbitrary and capricious. And the government always needs a rational basis. The government can't act arbitrarily. The government needs a reason. Any reason will be fine. But like, if that's what you mean, then sure. But that's just kind of a truism. The advisory jury found that it was unreasonable to consider budget. Well, I suppose in one sense that would be true. Well, no, not even then. I'm not necessarily sure. But the only things we were allowed to consider was human safety and human health. So maybe considering budget is unreasonable, definitionally. Although, money seems like it's important, but maybe the people of Oregon don't care how much they spend. Maybe they think the money comes from the ether. Where does all this government money come from? It just comes from places. The government has so much money. Where does it come from? I don't know. Let's spend more of it. Riparian plantings. Ooh, that's water. Americans with Disability Acts and the Building Code, all opportunities that are within the budget, according to the jury. The conditions and restrictions declared by the defendant are easily revised. Well, I suppose in so much as they could pass another law, I guess. The city needs an opportunity or chance to fix the public access. Perhaps the timing of this opinion provides the opportunity to do so. Clearly, the city may not violate the public trust doctrine and shall correct the violation. The court has the authority, based on evidence, jury verdict, tell the video to take down no access signs and remove the restrictions. The resolution is unlawful and the ruling applies. I hate this ruling, and it's sloppy. I hate this ruling, and it's sloppy. Now, the court may be right in the end. Right? I don't know whether or not the court is right in the end. But, public waterway, people should have a right to access it. Seems pretty basic. And you can't make it impossible to access government, right? That makes sense. So, in the end, these may be the correct decisions. The reasoning sucks. The reasoning is superficial. Conclusory, doesn't really balance counter considerations. And it seems to be all based on the idea of progress in and of itself, which incidentally, you didn't even need the framing device. You didn't even need all that introduction. That introduction was bullshit. You didn't need all that framing device. The time has come. You didn't need all that bullshit. You didn't need it at all. You could have just started with, hey, public waterway belongs to the public. You got to give the public access to it. The public can't get access to it. Government, that's a problem. Right? You didn't need this, it's time for a change. Change has come. It's like, you don't. It doesn't really work. And as to whether or not that this is a permanent lake or whether or not it's part of the lake or not, right? Those are questions that I can leave for another day. Right? Maybe it is part of the other lake. Maybe it's not. Maybe it's a part-time lake. Maybe it's not. Although just because it's a part-time lake doesn't necessarily mean that it's not a public lake when it's there. Right? Because streams and waterways can sometimes be part-time. So that's not necessarily a deal breaker. So sometimes it's a part-time lake. But when it's it's a part-time lake that's owned by the public, that can be fine. But we just went on and how this relates to women being able to be judges and women being able to have bank accounts, I don't know. Or the fact that we shouldn't discriminate on the basis, all their examples were like discrimination on the basis of sex, weren't they? How does discrimination on the basis of sex have anything to do with this? Let's go back to this examples. Women didn't used to be attorneys and judges, yet here we are. Okay, so discrimination on the basis of sex is bad. Old deed-in properties used to prevent ownership to minorities. Okay, discrimination on the basis of race is bad. In 1972, they passed Title IX that says, stop discriminating when it comes to gender. Okay, discrimination on the basis of sex is bad. Women couldn't own bank accounts, but now they can. Okay, discrimination on the basis of sex is bad. Hey, same-sex couples couldn't get married. Discrimination on the basis of sex is bad. And then we get to the lake. How does discrimination on the basis of sex, with one example about discrimination on the basis of race, have anything to do with lake? How do you get from discrimination on the basis of sex is bad, discrimination on the basis of race is bad, now I'd like to talk to you about a lake? How does that work as a flow? I don't see the flow of this river, man. I'm having a real hard time getting from discrimination on the basis of sex is bad and discrimination on the basis of race is bad and getting to lake access. Unless we were saying women can't access the lake, but men can. If that was the city code, I'd be on board with the analogy. If the city code was only men get to use the lake and none of those women, no women allowed in the lake, men, this is a men only lake. If that was the regulation, I'd understand the analogy a lot better. But that wasn't the issue, so I don't know why the hell we're talking about it. What the hell kind of prelude is this? It has nothing to do with anything. The non sequitur is causing my brain to reset. The non sequitur is causing my brain to reset. Discrimination is on the basis of sex is bad. Also, people should be allowed to take their boats on a lake. What? How are you getting there? I don't know. Yeah. You forever look forward to presenting the life changes argument before the Supreme Court. I would not recommend going to the Supreme Court on the basis of life changes, man. Therefore, that wouldn't be that wouldn't be the one I'd go with. Maybe we're not Organian enough to understand. That must be it. That must be it. Isn't Oregon the one with the two-sided flag and they've got a beaver on the back of their flag? Maybe the beaver can explain it to me. Yeah. Unless Syracuse Brad, right, exactly. Unless it is strange women lying in ponds distributing swords, I'm not sure how we got from any of those examples to whatever we're talking about. I don't know, man. I don't know how we got there. This is a poorly written decision. This judge is a hippie. Who? The Honorable Kathy Steele signed this. Kathy Steele. I'm getting the sense that Kathy Steele might be a bit of a hippie, but she's Oregonian, so I repeat myself. Maybe there's a connection between women and beavers. Maybe, Tony. Maybe that's what it is. I don't know. Is it a trans lake? Well, it is a part-time lake. Apparently, someone in chat said it's a part-time lake, which I suppose makes it a trans lake. It's a dry hole that occasionally identifies as a lake. I guess. Yeah. It's a fluid lake. Don't try to define it. Maybe. Well, this has been a stupid case. I'm going to have to rename this stream. I didn't know what this was when I started it. One of my mods just sent it to me and like, you should discuss this. This is just badly written. It's a badly written decision. There are so many more ways to go about this. He could have kept this a lot simpler. It's like, all you have to do is really say, once you conclude that it's a public trust, once you get that far and conclude it's public trust, all you then have to do is be like, well, given that the people have the right to access it, you're not allowing them to access it anywhere. Therefore your regulations are bad, and you got to come up with better regulations so that people can access it. It's like you can keep this really simple. It's like you don't have to overcomplicate this. It's Oregon. I'll break my brain trying to figure it out. Yeah. I really don't know how old deeds that prohibit sale to minorities. I don't know how that has much to do with anything. Yeah, the argument over who the lake belongs to is the least interesting thing about it. That's the least interesting thing about it, this decision. The argument about who owns the lake and who can access the lake is the least interesting thing about this decision. It turns out. All right, well, I guess I'm going to sign off. So if you guys see more stories like this, if you guys see more like quick hit stories, we can do more live streams, because I'd love to do some more live streams. This is just badly written. Try harder. Try harder. Try to figure out what standards apply. Am I allowed to restrict access to the lake beyond for reasons other than human safety, or am I not? I'm so confused. I guess I'm going to sign off for now. It's been fun. I'll talk to you soon. Have fun.